Well, today, the Georgia 19 became the Georgia 2 and the Georgia 17, at least for now. It was a good day for Georgia's Fulton County District Attorney Fani Willis and her team of lawyers who won round one of what will be the fully televised trials of the Georgia 19. Two of Donald Trump's co-defendants in Georgia were in court today through their lawyers asserting their right to a speedy trial, which is now scheduled for October 23rd. And they were asking the judge to sever their speedy trials from each other so that they could be tried separately and speedily. Judge Scott McAfee, ruling from the bench in real time on live television, denied the defense request to sever their trials and ordered the two defendants, both lawyers, Sidney Powell and Kenneth Chesbrough, to go to trial together. If any other defendants demand a speedy trial, they will probably be added as defendants in the speedy trial of Defendant Powell and Defendant Chesbrough, depending on exactly when they ask for a speedy trial. The prosecution revealed today that they will call, quote, in excess of 150 witnesses in a trial they estimate will last 120 days, not including jury selection. One of the reasons the prosecution convinced the judge not to sever individual defendants for individual trials today is that, according to the prosecution, quote, all of the evidence is admissible against all of the defendants. The prosecution is still insisting that all 19 defendants should be tried together in one trial under the speedy trial schedule, even though most defendants in the case clearly do not want a speedy trial.
It just seems a bit unrealistic to think that we can handle all 19 in 40-something days. That's my initial reaction.
If you have never seen a 34-year-old judge before, welcome to the club. No one has ever seen a 34-year-old judge with less than a year's experience on the bench handling such an important case. Judge McAfee was appointed by Georgia's Republican Governor Brian Kemp. He is now the judge under the most pressure of any of the four judges hearing criminal cases against Donald Trump, because Judge McAfee has to handle 19 defendants in his Trump case, and he has to deal with the intense pressure of Georgia's speedy trial law in a case that will include a massive amount of pretrial discovery evidence and that must be presented by the prosecutors to the defense, and a prosecution that expects to call 150 witnesses. The judge has to envision a trial with more than 150 prosecution witnesses who will be cross-examined by each of the defense attorneys in the courtroom, which could mean 19 consecutive cross-examinations of the same witness if all of the defendants are tried together. Judge McAfee could not have been more impressive in his first televised session of presiding over the case of the state of Georgia versus Donald J. Trump and his 18 co-defendants. Judge McAfee quickly focused on the issues before him today and made his ruling the old-fashioned way, right there on the bench the moment the lawyers finished speaking, ordering the two defendants who want a speedy trial to go to trial together, very much against their will. The judge did not end the hearing and then go into a conference with law clerks for a day or several days to help him write his ruling. He simply announced it on the bench. And with the high-speed pressure the case is now under for at least two defendants, we can expect to see more of that.
We're on an expedited timeline with these statutory speedy trial demands, and we are certainly here ready and willing to provide both defendants that right, and we plan to make that October 23rd trial date stick. With that in mind, I don't know if we're always going to be able to have the luxury of pre-hearing briefing and post-hearing briefing, and some of these issues may require a little more exploration than others.
Stuck poop makes thin women look fat. Can't go? Do this to clear out stuck poop fast.
Fiber helps you poop, right? Nope. What about drinking lots of water? Nope.
And before we get to what we were just discussing, I want you to listen to the latest testimony from Donald Trump, bravely delivered on a fawning right-wing radio show today, in which Donald Trump tells a very big lie. It's the kind of lie he's told before. Let's listen to this.
So if you have to go to trial, will you testify in your own defense?
Oh, yes, absolutely.
You'll take the stand.
That I look forward to.
No, I think that obstruction charge is going to get the trial, Mr. President. I think that.
I'll testify.
Okay, if you do, and they ask you on the stand, did you order anyone to move boxes? How will you answer?
I'm not answering that question for you, but I'm totally covered under the law.
Okay.
If you read the Presidential Records Act, just read it. You take a look at it. I'm totally covered under the law. It's a civil act. It's civil.
Bradley Moss, so I guess Donald Trump's going to testify because he would never lie about that on a radio show.
Yeah, there's no way on earth Donald Trump is ever going to take the stand. His lawyers will throw their bodies in front of him before they ever let him get on that stand. The man's a walking perjury machine. He would never put himself in that position. But what was interesting from that interview with Hugh Hewitt was that Trump kind of made a confession here about how he doesn't understand the law, and that could come back to bite him if this gets to trial, where he says, "So I can do whatever I want. Everything comes to the Presidential Records Act. I can do whatever I want." Well, that's not the law. And there's going to be jury instructions, no doubt, if this gets to trial and gets to the jury verdict, in which the judge outlines how that is, in fact, not the law, how the law still applies in terms of obstruction provisions, in terms of the Espionage Act, that everything Trump was spouting off and what he seems to believe, despite what his lawyers kept telling him, is not, in fact, accurate. And that will be his undoing if this gets to a verdict.
Harry Lippman, Stanley Woodward's filing today in the case is a very, very, very strange filing for many reasons. But the essence of it is he is asking to have his own client, Walt Nauta, examined by the judge to assure the judge that Walt Nauta sees no conflict of interest with Stanley Woodward representing him. But more importantly, even than that, he's asking that the star witness in the case be banned from testifying in the case because he says it was unfair for Jack Smith to use a Washington, D.C. grand jury to obtain that evidence from that witness, which produced the superseding indictment, the extra indictment of Donald Trump and his co-conspirators in Florida.
Yeah, and the way you put it, it's how he puts it. There's no case authority at all. He just says the proper remedy is to exclude him. But excuse me, there's, that this is the star witness. And yes, he asked for the Garcia hearing, but I think it's more accurate to say he agrees or concedes they've got to do it. Woodward is really up to his ears, not simply with these two, though it's the most vivid example, but he's paid for by Trump. He's been representing everybody. And so-called employee number 4 is Tavares, is someone he did represent. Then Tavares went back and got a public defender who told him, you know what, you're crazy. You should tell the truth and cooperate. And that's demonstrable. You know what else is demonstrable? The same is true for Nauta and De Oliveira, the other two, that they are letting themselves go forward with Woodward's help on charges of obstruction when they could almost certainly cooperate and at most only have to face liability for false statements. In order to serve Donald Trump, it's just baffling and just completely against their own legal interests. We'll see if they now follow suit, because there's going to be this dynamic. The two of them who can't talk to each other are wondering who's going to go first. It's sort of a prisoner's dilemma. Who will run to Smith? Let me cooperate as well.
So, Bradley Moss, there is the oddity of the defendant's, the client's dilemma. But what about Stanley Woodward himself? What is his obligation in this situation? If he's aware of a conflict of interest that seems very apparent to everyone looking at this, doesn't he have an obligation?
Yeah, so all lawyers, your ultimate obligation is to the client, not to whoever pays the bill, but to the client. And so in this context, Stanley Woodward has to be convinced for himself that he has done everything reasonable, his proper due diligence to ensure that he's serving Walty Nauta's interests, that he properly served Tavares' interests when he was representing him, that he's doing for these various other individuals. I believe even Peter Navarro in the contempt hearing or contempt trial right now is his client. He has to undertake those proper due diligence efforts to ensure he is representing their interests and advocating their rights and interests, and not considering someone else, not putting them at risk in favor of whoever's paying the bill or another client.
Harry Litman, he's just going to go ballistic. That is on an audio recording made by one of Donald Trump's criminal defense lawyers talking to another Donald Trump criminal defense lawyer about what Donald Trump would do if anyone tells him he has to obey the law about the documents that are illegally in his possession. He's just going to go ballistic. Is that evidence from the lawyer's notes, the audio recording and the transcript of those notes? Is that going to become evidence introduced in this prosecution?
You bet. And it's another example. People who deal with Trump know they better get a tape and use it. And Corcoran knows the reason he did it right away is under the evidence code. If you immediately, it's called a present sense impression, but that makes it admissible. And it's another example, you know, going back to Jim Comey and Raffensperger and Mike Cohen, people know who deal with Trump. They better get a tape, lottie. And it turns out, in fact, that these are situations where Trump thinks it won't become evidence, and it will. It's going to be incandescent evidence. We already had the evidence of what if we don't comply, and now this caps it, where we know he pays no attention, Trump, to what Corcoran's saying, and then another lawyer comes up and says he's going to go ballistic. He'll say not do it at all. It's all admissible, all against Trump, and man, that sort of 45 seconds of dialogue is just murder for Trump.
Yeah, Bradley Moss, it's hard to imagine. I just don't understand how the defense could survive that kind of evidence coming in.
If it gets in, yeah. If this gets to trial and those kinds of pieces of evidence are there, Trump is toast at trial. This whole case, and we've been saying this at the beginning, hinges on the pretrial motions. And one of them will be, in this case, in terms of Corcoran's notes and everything else he testified to, it'll be a motion to suppress, basically trying to reverse the original grand jury judge decision with respect to allowing this in, basing it on the the crime fraud exception to attorney-client privilege. That's going to be relitigated as part of pretrial motions. Trump has got to get that stuff out, because if it does get in at trial, yeah, he's toast. It's over.
And he has the most favorable judge he could find in the country who might try to rule in his favor on those things. Harry Litman, Bradley Moss, thank you very much for joining us again tonight. Always appreciate it.
Good night.
Thank you.
Thanks, Brad.
In a world where dry eye symptoms keep coming back, inflammation in the eye might be to blame.
Feel the ache and burn.
One man learns the truth. Over-the-counter eye drops typically work by lubricating your eyes. They may provide temporary relief,
But probably won't touch me.
Tell me there's another way!
There's hope for lasting relief with Xiidra. Xiidra works differently, targeting inflammation that can cause dry eye disease.
Xiidra!
Xiidra treats the signs and symptoms of dry eye disease. Don't use if you're allergic to Xiidra. Common side effects include eye irritation, discomfort or blurred vision, and unusual taste sensation. Why wait? Ask your doctor about a 90-day prescription and pay as little as $0. Xiidra. Not today, dry eye.
Collateral estoppel. No one has beaten Donald Trump in court more than E. Jean Carroll, and she did it again today with two words that Donald Trump obviously does not understand. Collateral estoppel. The legal doctrine of collateral estoppel prevents relitigating an issue that has already been resolved in a previous case. Earlier this year, E. Jean Carroll won a jury verdict of $5 million in a defamation case against Donald Trump for what he said about her in 2022. E. Jean Carroll was already pursuing a separate defamation case over what Donald Trump said about her in 2019 when he was still president and able to delay the progress of that case because he was president. And because what Donald Trump said about E. Jean Carroll in 2019 and 2022 were so similar, E. Jean Carroll filed a motion in the current case for a summary judgment against Donald Trump without having another trial on the evidence, since that same evidence was already used in the previous case. Today, the federal judge hearing the case cited collateral estoppel in ruling in favor of E. Jean Carroll. The judge said Ms. Carroll's motion for partial summary judgment is granted. The trial in this case shall be limited to the issue of damages only. Mr. Trump's motion is denied. In a statement, counsel for E. Jean Carroll said, "We look forward to trial limited to damages for the original defamatory statements Donald Trump made about our client E. Jean Carroll in 2019. Joining us now is Faith Gay, former prosecutor for the Eastern District of New York, federal prosecutor. Faith Gay, so what we have here is just the money section of the trial. The judge has skipped the whole necessity for a trial on the evidence with witnesses, saying, nope, we don't have to do that again. We can go straight to evaluating how much money should E. Jean Carroll get for this one.
That's exactly right. It's a way of substantially streamlining the case. It only happens when you have identical parties and they've each had a full and fair chance to litigate this identical issue before. Here the issue was whether President Trump, at the time he was president, 2019, lied and intentionally lied and hurt Ms. Carroll's reputation when he said that she was making a false statement in accusing him. She was doing it for an ulterior political, monetary motive. And so the judge found essentially the statements made in 2019 when the president was still in office were exactly identical in their content to the 2022 statements for which he's already been found guilty and liable.
You know, it was a big day for collateral estoppel fans because it's one of those phrases that has life in law school, but I, for one, have never seen it work so effectively and powerfully as it did today.
Yeah, look, I mean, it's sort of a nerdy person's dream, right? Yeah. Collateral estoppel doesn't trip off the tongue, but it is a doctrine that is rooted in basic fairness. It's never applied unless you have exactly the same parties, unless there's been a chance to really fully litigate the issue, unless there's been a determination by a fact finder, whether it's a judge or jury, here a jury, that in fact the defamatory statement occurred. And here not only was there a finding that the defamatory statement occurred, the jury found that Trump sexually assaulted Carroll. And that is another way of cross-proving that the statement was defamatory. Since the jury found that he assaulted her, sexually assaulted her, his statement by force is in fact false because he says it never happened. She just made it up, and the jury found exactly otherwise, both in their defamation verdict and in their sexual assault verdict.
So what is there a way of foreseeing what it might mean to the decision in the amount of money she's awarded in this case? The fact that there isn't even a trial on the evidence, would that likely increase the amount she would be awarded or have any effect on the amount she'd be awarded?
Well, it's a really interesting point. First of all, this particular trial involves 2019 statements, Lawrence, when the president was in office. And there's certainly an argument to be made that the full force of the presidency was put behind these accusations and destructive accusations of Ms. Carroll. So one would think that that statements made by the president when he was in office would have more effect in terms of destroying someone's reputation. But also the jury's going to know there's already been a finding of liability, and that seems to make damages higher too.